and instructions from the speaker. So this session will be very useful to all of you. A very few words about this workshop constituted under the Ministry of Human Resource Development of Government of India. The Government of India is taking several steps to bridge the gap between the academia and the industry. Most of the graduates coming out of our country in any discipline, be it of arts or engineering, do not find a fit aspects which prevent them from directly getting into a job in the industry. So the Government of India had started an initiative under the banner of Institution Innovation Council and is carrying out a lot of constructive programs to motivate, encourage and facilitate all the institutions and therefore the entrepreneurs, the students to join the programs of various programs organized by the government, say Startup India, Make in India, Amrit Mahotsav, like that. There are several programs which are organized by the Government of India, which is to motivate and encourage students to become a successful entrepreneurs, organization for a salaried job. So the country has got a lot of potential and tremendous resources which are yet to be tapped by the government. So that is why the government has come out with this initiative by starting a appropriately labeled organization, I should say, and the faculties involved in the IICs of various institutions. So we have to be a part of those council and carry out the programs constituted by the IIC of MHRD guidelines. So with these few words, I once again welcome Dr. Anand, who is our alumni. As I said, he doesn't need an introduction, who is going to conduct today's workshop on this IPR. So I once again welcome him and I request the participants to pay special attention to the program that is being organized by Department of Biochemistry, Dwarkadas Govardhan Das Vaishnav College today. Thank you.
Welcome the challenges. Welcome the challenges. Look for the opportunity in every situation to learn and grow in wisdom. I would like to call Mrs. Vaidehi, Assistant Professor, IPR Cell Member, to introduce our speaker. Please, ma'am.
Thank you, Netra. I am profoundly delighted to take the opportunity to introduce the resource person for the day, Dr. Anand Ray Swami. Currently, he is working as the Lab Director, IRIS Laboratories and Director, R&D, Hexacare Lifesciences. After his PhD, he worked with Department of Biochemistry, Siddha Central Research Institute, Chennai as SRF on the project Evaluation of Pharmacological and Toxicological Effect of Speranthus amaranthus shivakarandai in gentamicin-induced acute kidney injury model. He is also our alumnus. We are very proud to have you here, Dr. Anand. He has also completed several certificate courses on principles of clinical pharmacology, NIH USA, postgraduate diploma in pharma business intelligence, Clinments India, Data Science Foundation, Inside India, PG diploma in IPR and patents law, Annamalai University, postgraduate diploma in computer applications, Axiom Computers. To his credit, he has a patent on patent number is IN 2019-410-11402. It is a collaborative work with Siddha Chelation Research Innovative Center, KTM, and it was awarded in 2019. Apart from his research, he has also teaching experience. He has acted as subject matter expert in bioagri. He has also served as Junior Research Associate Patent Research Service in GVK Bioinformatics, Chennai, India. He has also published several articles in national and international peer-reviewed journals. He also worked as an executive life science IP on Scope E-Knowledge Center, Chennai. He has performed patent searches like prior art, FTO, invalidity, infringement, patent and market landscape analysis after conducting exhaustive market analysis. He has also served as Junior Research Associate Patent Service in GVK Bioinformatics on patent searches like prior art, FTO, invalidity, infringement. He has also coordinated with attorney to conduct claim analysis and accelerated examination search. He has also carried out secondary market research and landscape analysis. I think he is an apt person to deliver, to conduct the workshop on IPR. Dr. Anand, I welcome you once again.
Thank you very much for a wonderful introduction, Dr. Vaidehi. The workshop, I would like to 1 minute.
Anand, can you switch on your video?
1 minute, sir. Yes. Am I visible now? Sir, I have two devices. From one, my voice will be coming, and from another, my image will be coming.
Okay.
I have a problem with
this setting, I'm not able to see your video. Okay, yeah, you can proceed. No way, no problem.
Hope my this thing is visible. PowerPoint presentation is visible to everybody.
Your presentation is visible.
Okay. Thank you very much for introducing me, Dr. Vaidehi, and I thank the Newburgh crew and the Innovation Council of DG Vaishnav College for inviting me for this talk in the workshop on intellectual property rights and IP management for startups. I feel that this is one of the right times for the students to understand about the intellectual property rights and the IP management, because there are a lot of startups coming in India on a day-to-day basis. For example, if at all we went back to in time and when I was a college student, when I was in post-graduation, when I saw the number of startups coming about, it was around few hundreds per year. But nowadays, it has crossed more than 5,000 startups per annum. And we can also see unicorn companies coming out of tier 2 and tier 3 cities. Previously, Chennai, Bangalore, Mumbai, Delhi, Kolkata was a major hub for startups or the industry. It is collectively known as industrial hub. But nowadays, all the this thing has been broken. The misbeliefs have been broken by the tier 2 and tier 3 companies, and n number of startups are coming, and n number of startups are getting money into their company, and they're driving the world nuts because Indian market is booming like something. Why? Because they're all lagging behind in technology compared to the developed countries such as US, UK, Germany, etc., etc. But we are slowly catching up. But it is a steady catch up where the technology is booming like something. If you go to Bangalore, Hyderabad, and even in Chennai, there are many technological startups that are coming, which are giving tough competition to the abroad markets. So everybody from abroad, whatever countries are pouring money inside India, and they want to be a part of the Indian business ecosystem. I want to coin this word, Indian business ecosystem, which was not prevalent in the 10 years back. Graduate, postgraduate students, this intellectual property rights or the IP management for startups is an essential topic, which is seldom understood by people, the students. Now let me go into the topic right away. I don't know to drag time. First, what is intellectual property or what is intellectual property rights? There are, see, it is going to be a little bit, what to say, informative, as well as it is going to be a little bit slow because this topic is a little bit tough to understand. If at all you have any doubts, please put forward your question in the chat box so that it can be answered later. We'll be discussing cases also. Okay. So first, intellectual property is nothing but creations which are given by inventors or art people, everything, even designers. You can go for graphic designers or symbol designers, or even who coin names or images. For an example, Facebook logo was bought for somewhere around $2 to $3, but now the logo carries a trademark which cannot be used by anybody else. And images, we go to Google, search images, but some watermark will be there on images. These are all comprise a part of intellectual property. So, what is intellectual property rights? It is a rights given to the person or the creator, because the intellectual property, the creation comes from their very mind. For example, if a student from DG Vaishnav College creates a new design for DG Vaishnav, okay, and it is very good, and already the design is there, it is being trademarked. So, the trademark design of DG Vaishnav cannot be used by any other institution across the world. It is what is it? It is constricted to the use of DG Vaishnav alone, provided they can give permission to use for others to use it. Or else, if others use DG Vaishnav logo without prior permission, it is a part of offense and they can be penalized for that. Whoever uses without the permission of DG Vaishnav, it is protected. The copyright of the particular symbol or the name is protected. For example, you can recently there is a T-shirt known as Balmain, worn by Dhoni, the superstars Allu Arjun, Shiva Karthikeyan, etc. Everybody are wearing Balmain T-shirts. Balmain is nothing but a brand name created by Terry Balmain. Okay, so that Balmain name is being registered or it is being trademarked. That name cannot be used by other creators or people who are designing t-shirts. They cannot use that logo in their t-shirts. It is trademarked for that particular brand alone. Likewise, each and everything is intellectual property and right given to. And coming to the first patent, which was given to a person, it was recorded back in 1421 in Florence, Italy. You might wonder what they were doing back in 1421. Manufactured a barge for transporting marble using a rope gear. So he was offered a 3 years patent. During those time, during the year 1400s and all, giving credit to the inventors was prevalent among the French people. French people are a little bit advanced in revolution, civilization, etc. Okay, so they came with a concept called patenting and giving credit to the inventors. So during that time itself, it was recorded. But the patenting system itself came into existence across the world in the year 1883, where first Paris Convention came into act, where it covered inventions, patents, trademarks, and industrial designs. You might wonder what trademarks and industrial designs are and patents are. We will be covering one by one in detail. Okay. Next came the Berne Convention. Berne Convention is nothing but a convention happened in that particular place called Bern, which is in Austria. Why this particular convention happened is that the people were invited into Bern for presenting their artistic and literary works, but in Austria, to Austria. But during that time, data theft, now we see, right? There were artistic theft during those time in Austria. So what this Bern and the European Union decided is that we have to introduce a system where the artistic and literary works or invention of people are covered across the globe or initially across the European Union. That's when Madrid Agreement was introduced, where the first IP filing. So a person who invents a new thing can go and patent and file a patent stating that I have invented this, and a document of registry was offered to the inventor so that he can claim that that particular invention has been discovered by him. Okay. So next came, it was given in the year 1891, and then came Burpee, Paris and Bern conventions combined together to form a organization called Burpee, which is Bureau International Reuniones por la Protección de la Propiedad, United International Bureau acronym for the French form of United India Bureau for Protection of Intellectual Property. It came into existence in the year 1893, but after that, after the World War, okay, there were talks across the globe that a global system should be introduced across countries where every invention comes under a single window, is being known under a single window. That's when WIPO came into existence. WIPO is nothing but World Intellectual Property Rights Organization or World Intellectual. Now WIPO has a membership of around 190 countries, including observership. Okay, like we have it in UN. But later in 1974, WIPO joined the UN Committee, United Nations. And in 1978, together they launched the PCT system. PCT is nothing but Patent Cooperation. Next, in 1994, even if WIPO had launched the PCT system, there were many arbitrations, or to be precise in words. So in 1994, there was a WIPO Arbitration and Mediation Center, AMC, which does the protection they require for their invention. Let it be your. I will give you an example. We write observing, we take a piece of paper, write the readings, and then copy into observation, and then transform it to record and get the signature of the faculty. Even that paper, where you can be produced as a proof to claim your idea or a patent. Another person registers in 20, he can claim that. So it is called infringement of an invention. Okay, this can all happen into existence. And then WIPO established an academy. Every world organization has an academy for learning, right? So WIPO Academy was established in the year 1998, and then it came into development agenda. Now WIPO offers pre-courses. You can get a certification from WIPO for intellectual property rights, basics, advanced course, everything is there. When get course on economics, every course is being offered from a business perspective and protection of intellectual property rights. What is an IP? What is IP and IPR? And what first patent and the timeline of WIPO formation. Now, everybody asks why should I have a document for patent invention? I can literally tell to a group of people that I have invented a I have invented something new, and this is mine. Everybody will accept it, but there is a principle. There are certain principles that has to be followed. A contract between creator and the sovereign state. Sovereign state is nothing but the country that we reside. For example, in this case, the sovereign state or the sovereign nation denotes our Republic of India, where it protects came as a principle here. Okay, so a document will be given by the government of India. This is the This is the document patent application form where you have to file, and the patent will be given stating that you have a proof of this invention is yours. Second, a balance between rights of creator and public interest. For an example, you invent a atomic bomb or a hydrogen bomb, and you for the public, so I cannot give patent because it can also be used for military purposes by the government of India. And if at all I grant you patent, you can sell it to somebody else who can use it to harm people. What government says, this will be the explanation, and it will deny giving the patent, or it will take the patent on its own. Government will say, give your patent to me, I cannot give this to you, even though you have invented it. It is on the right. Knowing a company called Volvo, Volvo. They were the first company to invent the seat belts, cross seat belt that we wear in car right now. Okay, there are two, 3-point car seat belt system that was invented by Volvo. Okay, the Volvo company did not patent it. Why? It was because of public interest. If that guy has patented, the Volvo company has patented a 3-point belt seating belt system, no other company or car company would have not been able to use it. But for public interest, Volvo company did not patent it. Now, recently, Tesla has, you know, right? Tesla, he's one of the biggest billionaire, and he's denied buying Twitter. So that Tesla, Elon Musk has given, and he will not draw you into cases. Elon Musk will not draw it into cases. So, and you can give new invent designs, geographical indication, semiconductor integrated circuit layout design, trade secret. We will see the and protection of plant varieties and farmers in the year 2001, but and no charge cannot be patentable. Mere discovery of substances as they naturally occur in the world. For example, turmeric. You capsule the turmeric and try to patent it as turmeric, it will not work. But you can patent the capsuling flow. Okay, capsuling methodology, which if it is novel, you can patent it. Diagnostic, therapeutic, and surgical methods of treatment for humans, animals, surgery, or a tool used in is being used in the open heart surgery cannot be patented. But the systems which used for monitoring and that technology can be patented. Plants and animals and other microorganisms and essentially biological processes for production of plants or animals. Obviously, GMOs are not patentable nowadays. Other than non-biological and microbiological process and computer programs. You write a new computer program, it will not be patentable under Patents Act. Rather, you can copyright it, computer programs. Okay, we will come into to that in the later part. Next, trademarks. Trademark is a unique sign or indicator. For example, these are trademark. Mahindra, Distillery, Bata, Yahoo, Volvo. We spoke about Volvo, right? Mahindra. Everything has a trademark. You cannot use this particular logo anywhere else without the permission of that particular company. For example, Volkswagen, everybody knows, right? There was a tagline for Volkswagen, Das Auto, DASAU, it in each and every other commercial where Volkswagen gives it. But recently, in after 2014, there was a case against Volkswagen from a auto dealer called Das Auto in North India. He successfully defended his case, where he defended that Das Auto was his father's company, and he has been maintaining for more than not coming into the Sweden, in a company called Sweden and in other European Union countries. The Das Auto, the tagline was removed. Why? Because it sounded very racial union. It was removed because it sounded racialistic, and it was removed out of public interest by the government itself. This is the difference between public interest and the next author is till the author or the literary presenter is alive. After he's given the copyright for particular. But when the producer gives money to Anirudh, and it can be applied by the producer, and he can claim the copyright. That is how it works. Next, these are the things that can be copyrighted. And a classical case in India in recent times. Okay, you know, right, Magadira film everybody would have watched, and there was a film called Rabta in Hindi from Bollywood, which was acted by Sushant Singh Rajput. When the trailer of Rabta got released, recent times, the makers of Magadira, namely S.S. Rajamouli, and the producer of Magadira film, when you copy and what the of Indian patent law, this is a critical. I want to clarify if there are there any doubts. Please let me know, because we'll be going to the next topic, IP management for startups. Sir, can I take 10 to 15 more minutes for this session? With your permission.
Yeah, you can take.
Thank you very much, sir. So we will be going into IP management for startups, which is very important and the need of the hour, as I said, as we discussed earlier while starting the session. Okay. Why IP management is required? For an example, I'll give a classic example, Tesla. In the year 2003 or 2004, when Tesla came up with the company registration, Many laughed at them because it was not possible. Where Tesla car, electric cars, and the rockets which can re-land after going into space. But now it is possible. Why? Because the patent was protected. Back then, Tesla was a tech startup. Now, Tesla is a $1 billion company. That is how you transform the company. Next, coming to Zoho. You know Zoho, right? Uh, Vembu, Sridhar Vembu is one of the classical example for copyright. Zoho has many copyrighted software in India and abroad, which makes it a $1 billion company. Back then, Zoho was just a startup. Similarly, there are many Indian companies, for example, even Bharat Biotech, let us say. Now it is producing vaccine for corona, but few years back, it was just a startup. But due to IP reforms and IP management, now each and is a impeccable rule. Okay, let us go and see. First, let us know what is a startup. A startup is a company that's in the initial phase of business. We all know what is a startup, right? No time management, no money management, nothing will be there inside a startup. The people will go bongers to come in to develop something, and after development, the society, the industry will go bonkers. That is how it works. Common characteristics of a startup company. It is innovative, solves problem, very quickly growing. For example, Oyo, scalable, flexible, higher risk, strong company culture, young in age, smaller teams, tech oriented, and often funded by outside investors. Oyo is being sponsored by SoftBank, etc., etc. Now Ola, Uber is also being invested. Hands on Ratan Tata's shoulders. He had a startup where he developed a sponsored by Ratan Tata. Next, Big Basket. Nowadays, nobody goes outside, orders in Big Basket, orders in Swiggy, orders in Uber or Zomato. Swiggy and Big Basket was sponsored by Ratan Tata, sorry, Tata Group. Big Basket is still a part of Tata Group. Okay, and Swiggy, I think Tata is also having share in Swiggy. Why? For their technology, and Ola for their GPS based traffic management system for rerouting the taxis up. Particular software is copyrighted. These are all startups which have become unicorn inside India. Okay. Next, traditional thinking. Why? Every startup thinks once an invention is there, of invention, that is what the exit of success. Protecting your invention, that particular startup, if that seldom worries about the IP management, what is it? That does not worry about the IP management field. Instead, they have to give a clear exit strategy because be investing in your company. If they see that your company is growing, for example, SoftBank and Tata, they are investors, angel investors. You might not know the person, but he will be interested to invest in your company. Venture capitalist, where a share of your company will be going to him, and he will be investing money for your shares. Those are all venture capitalists, angel investors will be looking for a better exit strategy if the company is going to fail and if the company is mismanaged. So, common exit plans. What is that? Mergers and acquisitions, selling the business, or taking the company public. These are the three major exit plans for a venture capitalist or an investor. But how it can be avoided? By classifying the assets that a company has into tangible and intangible assets. What are the tangible assets? Cash at hand, land, equipment, inventory, machinery, furniture, stock, and bonds that a company has. Rather, intangible assets, patents, trademarks, copyrights, goodwill, brand recognition, internet domain names, customer list, employment contracts. For example, Practo. Practo, everybody would have used. It has the list of customers. It has internet domain, and the brand is being recognized. And it also has goodwill. Previously, like Zomato, where Zomato was initially a app where we used to enter the review for a hotel, but due to its goodwill from the customers and due to its expansion strategy, it was what is it? It was sponsored by some funding agency. Now, Zomato is one of the biggest delivery partner across India for food delivery partner, right? Now Zepto is coming, 10-minute delivery. Everything has patent, their goodwill, brand recognition, and all. It's there. That is why many people are investing. Mapping intangibles, assets to IP rights, which is very important. We saw patents, trademarks, copyrights, everything, right? That has to be mapped where patent, it is technology. Trademark, it is a brand. Copyright, it is a brand. Trade secret, it is a brand. So copyright, data, secrets, everything comes into data. Data, technology, and brand. All the three intangible assets combined together makes the IP of a startup very strong. So it can be either, that is where you focus, where IP plus money gives the lifeline of the company, where you can achieve success. Start right from the starting to protecting your IP, to transfer of technology to your production manufacturing department, to startup creation, to pull in funding and to create a foolproof business plan, to develop your technology, to go for strategic partnership with other company now, and exit to success means your company is going into success. For example, I can say Actavis Pharma in USA. Okay, now Actavis Pharma is in India also. It was acquired by Teva Pharmaceuticals from Japan. Those two companies are different across geography, but Teva Pharmaceutical acquired Actavis Pharma due to its intellectual property, monoclonal antibodies and molecules for treatment of various diseases. When the Teva Pharmaceutical found that the product produced by Actavis Pharma was similar to its product lines and it wants an expansion across the globe, Teva Pharmaceuticals acquired Actavis Pharma. Now it is Teva Actavis. Similarly, now recently you would have checked 1mg, Tata has acquired 1mg, right? And PharmEasy has acquired Tyrocare, where PharmEasy was a pharmacy, Tyrocare, where Tyrocare was a together, they can acquire data. That is what I told. Data, trademark, copyrights, trade secrets, patents, everything owned by Tyrocare was purchased by pharmacy. Copyright each and every app that you use in mobile. For example, Apple has many copyright protection for its interface, for its app model, everything, design, everything it has. You cannot copyright protection. Okay. Next, what is the best of IP portfolio? How to develop your IP portfolio? Being a startup, first offensive, second defensive, and three strategic portfolio. These are the three different methodologies where offensive is nothing but patenting your creation and protect the core technology of the company. Defensive portfolio is a risk mitigation strategy where you check whether your company's core technology is infringing some other's patents. If at all it is infringing, you can buy the patent or put an agreement with that particular company. For example, Samsung and Apple does agreements. Apple gives protection to Samsung. Apple uses Samsung's core technology for its core processor. Okay. Similarly, there are many things. Samsung's Gorilla Glass display is being used by Samsung phones and many phones. Even Apple may use Gorilla Glass. Gorilla Glass is a patented technology which is being shared by many companies. So this is called defensive portfolio. Next comes strategic portfolio. Strategic portfolio in the sense you collaborate and cross-link with many companies. For example, one company, for example, my company has a core technology which is linked to many other which has a link for many other companies. For example, Bluetooth. Bluetooth is a common technology that was previously used for defensive purposes. Okay, but later it came into public usage, and the particular patent is being used by others. It is called a strategic portfolio, and you can also find Apple in Samsung, tablets. Okay, that are all are patented technology from other company which Samsung will buy for increasing its strategical benefits. Next, IP management strategy. What is the best IP management strategy? Apart from all these, keep your employment work separate from your new idea. Don't let other people claim ownership of your IP or your company. Have contributors assign their IP to the company. Evaluate your core assets and decide on the type of IP protection you need. Make sure you have a great name. Great name is nothing but a brand name that you create. patent strategy that should be cost effective and not avoided. The patent strategy should be simple and cost effective, but it should not be avoided at any cost because it gives advantage to your company. Consider a global patent strategy, including China. When you go for patenting, many country application initially. Once you file a patent PCT application, it can be claimed in India, as well as you will be getting 12 months time for filing your country application in US and whatever country you decide to file it. And take care in using open source software. For example, if you are using Microsoft Office in your company, or even in my company, I don't purchase it and use a pirated software, my company can be sued. Instead, if I use an open source software like King Office, which is open source, my company will not be sued. These should be done. Moreover, when you use a go for patenting, if you develop a new technology from open source, it can be a useful path from your end, because you don't have to go for a strategic partnership with other company because it is an open source one. Okay. Only litigate IP dispute out of principle in rare cases. Out of principle, what are the principle? Two principles. Principle, you can go for IP litigation where it is infringing the public, or it is being used for some other use which is not useful for public. Last but not least, when you hire a new employee, be careful that he does not steal any of your technology from the company and gives it to others. These are the effective IP management strategies, and these are the 6 things startup needs to know about IP. File early, file your patent as early as possible, so that you will be having a date which is given earlier, which can be claimed to use your patent. Additional filing. If you want to file additional patents on your existing patent, you can go very well. Prioritize. Line up the protection according to overall business plan. You have to build a IP portfolio according to your business plan. That is what it means. Trade secret. Trade secret, as of now, in India, it is not available, but across the globe, it is available. Worth of the invention. Conduct market, business, and search analysis. We used to conduct many analysis, infringement analysis, prior art search. Everything will be conducted, market analysis. Everything will be conducted in order to check the worth of the invention. How can I build the IP portfolio, and how can I make money out of my IP? That is what I will think. And types of IP protection. If at all you bring out a particular creation, check under which criteria and all it can be protected. For example, patent, copyright, trademark, everything. The Indian government has present. Startup India initiative and Make in India initiative. That is a recent government initiative. They have fastened the patent examination. For example, previously it was around 18 to 48 months. Now you can get a patent within the span of it was around 8,000 or 10,000 something. Now, SIPP, Startup Intellectual Property Protection. There is a separate IP protection cell for startup itself to help you with IP management. It is being supported by the government of India. And support for international patent protection in electronics and IT. You come up with a new electronics or IT, it is being supported by the government for protection abroad also. Schemes for MSMEs. There are many schemes for MSMEs for patenting. Accelerating growth of new India's innovations. And cell for IPR promotion management, SIPAM. These are the 2 new institutions that have been formed by the government for the protection of local inventors.
Yeah, that's okay. Taking extra time is not a problem. So you gave a lot of information on the various aspects of the IP management. That was highly stuffed with a lot of information. I hope the students would have just noted down the important points,
Yes.
What is required for filing a patent, and the filing for a patent, is it something like, oh, now I have to go for filing a patent, so I have to work something separate, something different, or what about a few programs organized by various departments in the college on IPR? Every program is just going like a normal seminar. People have the students, they have a paper on that and say, though they take some notes and that's it. But to make it in a much more realistic sense and to get more benefit out of all these resource persons from various resource persons like you, ஒரு ஸ்டூடெண்ட்டுக்கோ ஒரு ஸ்டாஃபுக்கோ வந்து பேட்டன்ட் ஃபைல் பண்ணணும் அப்படின்னா அது பண்ணி தான் ஆகணுமா? அந்த மாதிரி ஒர்க்கை தான் நாங்கள் ஒன்றும் பண்ணலையே. இப்போ பேட்டன்ட் வாங்கி வச்சு நாங்கள் என்ன பண்ணுறது? இல்லை பேட்டன்ட்டுக்கு தனியாக ஏதாவது வேலை பார்க்கணுமா? அதெல்லாம் முடியுமா எங்களால்? அப்படின்ற மாதிரி சில பேசிக் கொஸ்டின்ஸ் இருக்கிறதுனால இந்த ப்ரோக்ராம்ஸ் எல்லாம் வந்து அந்த அளவுக்கு எதிர்பார்க்குற அவுட்புட்டை வந்து கொடுக்க மாட்டேங்கிறது. மேபி இட் மே டேக் சம் மோர் டைம்னு நினைக்கிறேன். ஐ டோன்ட் நோ. மேபி இட் ஷுட் டேக் சம் மோர் டைம் ஃபார் எவ்ரிபடி டு கெட் மோட்டிவேட்டட். ஸோ உன்னோட தாட்ஸ் இதில் என்ன? வாட் யூ சே அபவுட் திஸ் பாயிண்ட்?
தமிழ்லேயே எக்ஸ்பிளைன் பண்ணலாம்னா, தனியாக ஒர்க் பண்ண வேண்டாம் சார். எப்பவுமே ஒரு ஒர்க் பண்றோம் அப்படின்னா தனியாக ஒர்க் பண்ண வேண்டாம். we have to check whether it is novel or not. அவ்வளவுதான். ஃபார் எக்ஸாம்பிள், நம்ம வந்து வெங்காயம், எனக்கு ஒரு சின்ன ஸ்டோரி மட்டும் சொல்றேன் சார். ஓகேவா? தேர் வாஸ் அ ப்ரொஃபஸர் ஃப்ரம் USA who came to India. சரியா? ஒரு ப்ரொஃபஸர் வந்து USA இருந்து இந்தியா வந்திருக்காரு. அப்போ வந்து அப்படின்னு சொல்லியிருக்காங்க. அந்த ப்ரொஃபஸருக்கு இனிஷியலா ஏன் பைனாப்பிள் அம்மா சாப்பிடணும் அப்படின்னு புரியல. பட் லேட்டர் வாட் he did, US போயிட்டு இதை பத்தி நிறைய தாட்ஸ் கொடுத்து he extracted collagen from pineapple. And he's selling it as a tablet. Collagen tablets இப்ப வருது இல்ல, it was one of the predecessor of that particular professor. அந்த பர்டிகுலர் ஸ்பீஷீஸ்ல இருந்து. ஸோ இத மாதிரி ரொம்ப சிம்பிள் தாட்ஸ் நம்ம என்ன பண்ணிக்கிறோம், ரொம்ப காம்ப்ளிகேட்டடா இருக்கணும், எப்படி சொல்றது, ரொம்ப காம்ப்ளிகேட் ஒர்க் பண்ணணும் அப்படிலாங்கிறது. தேர் இஸ் அ சேயிங்ல சார், என்னன்னு கண்டுபிடிச்சு அந்த சிம்பிள் சொல்யூஷன், இஃப் இட் இஸ் நாவல், ஒரு ஸ்டார்ட் அப் போனோம்னா 80% டிஸ்கவுண்ட் தராங்க ஒரு அப்ளிகேஷன் ஃபார்ம்லயே. 1600 to 1800 முடிஞ்சிடும். அதுக்கப்புறம் போறது மேக்ஸிமம் 25,000 பேட்டன்டே வாங்கிட்டு அந்த பேட்டன்ட் என்ன வச்சுன்னு பண்றதுன்னு தெரியாம, இஃப் யூ கேன் கொலாபரேட் வித் அன் இண்டஸ்ட்ரி. ஃபார் எக்ஸாம்பிள், தேர் ஆர் மெனி இண்டஸ்ட்ரீஸ் நவடேஸ் கமிங் இன். ஒரு ஸ்டார்ட் அப் கிட்ட போய், இல்ல ஒரு காலேஜ்ல இருந்து ஒரு பையனே வெளியில வரான் அப்படின்னா அவங்ககிட்ட அந்த பேட்டன்ட் கொடுத்து அவனுக்கு வந்து கவர்மெண்ட் கிட்ட பேசி ஃபண்டிங் வாங்கி கொடுத்து they can share the benefits. ப்ராஃபிட் இருக்குல்ல, அதை வந்து டிபார்ட்மெண்ட்லேருந்து வந்தது. ஸோ காலேஜுக்கு ஒரு ராயல்ட்டி வரும். ஏன்னா மேக்கப் அந்த ப்ராடக்ட் வந்து ப்ரொடியூஸ் பண்றதுக்கான காஸ்ட் இருக்குல்ல, அதை வந்து வில் பி போர்ன் பை தி கவர்மெண்ட். ஒரு ஃபண்டிங் தராங்கன்னா கவர்மெண்ட் வந்து அந்த ஃபண்டிங் கொடுத்து அந்த பையனை வந்து தூக்கி விடும். ஹிஸ் கம்பெனி வில் பி ஸ்டார்ட் அப். ஸோ ப்ராஃபிட்ஸ் வரதான் அந்த கம்பெனிக்கு போகும். பட் அந்த பேட்டன்ட் யூஸ் பண்ண ராயல்ட்டி வில் பி கமிங் டு தி டிபார்ட்மெண்ட். அந்த பேட்டன்ட் ராயல்ட்டி எவ்வளோ வந்து காலேஜுக்கு தரும், அதான் வில் பி புட் அக்ராஸ் பை பைண்டர் அக்ரிமெண்ட். ஸோ இதுதான் அதோட யூஸ். நோ காம்ப்ளெக்ஸ் டெக்னாலஜிஸ், நோ காம்ப்ளெக்ஸ் தாட்ஸ் ஆர் ரிக்வயர்ட். நம்ம படிக்கிற லிட்ரேச்சரை ஒழுங்கா சர்வே பண்ணாலே த இன்வென்ஷன் தட் இஸ் கம்மிங் அவுட் வில் பி நாவல். அதுதான் ப்ரையர் ஆர்ட் சர்ச்னு சொல்லுவோம். ப்ரையர் ஆர்ட் சர்ச் அப்படின்னா முன்னாடியே ஏதாவது லிட்ரேச்சர் இருக்கா இந்த பர்டிகுலர் கான்செப்டை பத்தி. நான் வந்து யோசிக்கிறேன், ஒரு சாஃப்ட்வேர் புதுசா பண்ண போறேன், இல்ல ஃபுல்லா ஒரு டயக்னாஸ்டிக் டூல் பண்ண போறேன் அப்படின்னா அந்த டூல் ஏற்கனவே லிட்ரேச்சர்ல இருக்கா அப்படின்னு செக் பண்ணும்போது, ஃபார் எக்ஸாம்பிள், பேட்டன்ட் அண்ட் நான் பேட்டன்ட் லிட்ரேச்சர் இருக்கு. பேட்டன்ட் லிட்ரேச்சர்னா பேட்டன்ட் மட்டும்தான். பட் நான் பேட்டன்ட் லிட்ரேச்சர் பாத்தீங்கன்னா நம்மளுக்கு வந்து ஆர்டிகல்ஸ், நியூஸ் பேப்பர் கிளிப்பிங்ஸ், கண்டென்ட் ரைட்டிங்ஸ் எல்லாமே கம்ஸ் அண்ட் நான் பேட்டன்ட். அது என்னாவது ஒரு இடத்துல இந்த மாதிரி வந்திருந்தா கூட இட் இன்ஃப்ரிஞ்சஸ். இன்ஃப்ரிஞ்ச்மெண்ட்னா நம்மளோட தாட்ஸ் வந்து அடிபட்டு போயிடும். அதோட நிற்காம அதை எப்படி மாடிஃபை பண்ணி அதை வந்து பேட்டன்ட் பண்ண முடியும் அப்படின்றது ஒரு பேட்டன்ட் அட்டார்னியால மட்டும்தான் டிசைட் பண்ண முடியும். ஏன்னா கிளைம்ஸ்னு ஒரு விஷயம் இருக்கு. அந்த கிளைம்ஸ் மட்டும்போது இட் வில் பிகம் நாவல்.
Yeah, thank you, Anand. So I just want to make students to realize that patents வந்து புதுசா ஒரு கான்செப்ட் இப்போ ஒரு few years we can say ஒரு 3 to 5 years the government is really aggressive-ஆ அதை பண்ணிட்டு இருக்காங்க. எல்லா ஹையர் எஜுகேஷன் இன்ஸ்டிடியூஷன்ஸ்லயும் அண்ட் அதர் முத்ரா லோன்ஸ் இந்த மாதிரி நிறைய விஷயங்கள் மூலமா தே ஆர் என்கரேஜிங் தி ஆண்டர்பிரினர்ஸ், ஸ்டார்ட் அப்ஸ், மேக் இன் இந்தியா, அந்த மாதிரி நிறைய பண்ணிட்டு இருக்காங்க. அது வந்து இந்த ஹையர் எஜுகேஷன் ஸ்டூடெண்ட்ஸ் லெவல்ல வந்து எந்த அளவுக்கு ஒரு இம்பாக்டை ஏற்படுத்துறதுன்ற ஒரு டவுட் எனக்கு இருந்துட்டே இருந்தது. ஸோ அதனால இந்த கொஸ்டின் நான் கேட்டேன் நான். ஸோ ஐ திங்க் திஸ் இஸ் அ ப்ராசஸ், இட் வில் டேக் சம் டைம். ஸ்டூடெண்ட்ஸ் எல்லாம் அவளோட அந்த பேட்டன்ட்னுடைய சிக்னிஃபிகன்ஸை தெரிஞ்சுண்டு அவள் பண்ணுற ப்ராஜெக்டோ இல்லை வேறு ஏதாவது பண்ணுறதோ வந்து எவ்வளோ இம்பார்ட்டண்ட்டாக இருக்குன்றதை அவள் ரியலைஸ் பண்ணி அதை நம்ம பேட்டன் பண்ணலாமான்னு யோசிக்க ஆரம்பிக்கும் போது தான் அதை பற்றி ஒரு ஐடியாவே அவங்களுக்கு கிடைக்கும்.
இல்ல
Probably அதுக்கப்புறமா வேணா they can really work towards something novel.
இல்ல அதுக்கு வந்து ஃபர்ஸ்ட் ஆஃப் ஆல் வந்து இப்போ ஒரு ஸ்டூடெண்ட் வந்து ஃபார் எக்ஸாம்பிள் நம்ம இந்தியன் அகாடமிக் இன்ஸ்டிடியூஷனுக்கும் அப்ராட்ல இருக்க அகாடமிக் இன்ஸ்டிடியூஷன்ல ஒரு டிராஸ்டிக் டிஃபரன்ஸ் என்னால பார்க்க முடியாது. ஏன்னா ஐ இன்டராக்டட் வித் பீப்புள் இன் ஹார்வர்ட், எம்ஐடிலாம் இன்டராக்ட் பண்ணியிருக்கேன் ஆக்ஸ்போர்ட் கூட. அண்ட் நம்ம இந்தியன் இன்ஸ்டிடியூஷன்ல இருக்கிறது இப்போ வந்து பாத்தீங்க அப்படின்னா அவர் அகாடமிக் இன்ஸ்டிடியூஷன்ஸ் ஆர் ஸ்லோலி கேச்சிங் அப். ஏன்னா அங்க வந்து பாத்தீங்கன்னா அந்த காலத்துல ஃபார் எக்ஸாம்பிள் 2010 அந்த வரைக்கும் the amount of patent coming out of an institution and collaborating with the organization, industrial organization was more. இப்போ அண்ணா யூனிவர்சிட்டி அந்த மாதிரி இன்ஸ்டிடியூஷன்ல பாத்தீங்கன்னா they are collaborating more with industries. நான் என்ன சொல்லுவேன் அப்படின்னா if at all ஒரு காலேஜ் இருக்கு அப்படின்னா அந்த காலேஜ்ல வந்து ஒரு ஸ்டாஃப் இருக்காங்கன்னா அந்த ஸ்டாஃப்க்கு வந்து ஒரு ஐடியா இருக்கும். அதை வந்து ஒரு ஸ்டூடெண்ட் வந்து பண்ணிட்டு பண்ற ஆரம்பிக்கிறதுக்கு முன்னாடி யூ கேன் டிஸ்கஸ் வித் அ பேட்டன்ட் பீப்புள் அண்ட் ஆல்சோ வித் அன் இண்டஸ்ட்ரி. இந்த மாதிரி நாங்கள் பண்ண போறோம், இந்த மாதிரி பண்ணா நீங்க எடுத்துக்க முடியுமா, அந்த காலகட்டத்திலேயே பேசி முடிச்சுட்டா we will be getting funding, enough funding to take out this, carry out the study. ஏன்னா எல்லா அகாடமிக் இன்ஸ்டிடியூஷன்லயும் வந்து ஃபண்டிங் ரிசர்ச் தான் ப்ராப்ளம். அது வந்து இண்டஸ்ட்ரி கிட்ட என்ன பண்ணல அகாடமிக் இன்ஸ்டிடியூஷன்ஸ் from BSc பார்ட்லயே நம்ம வந்து
Okay, thank you Anand, that was really highly informative and I should say stuffed